The insurance adjuster calls you. They're friendly, they're sympathetic, and they've got a check ready with your name on it. Sounds great, right? Wrong. That check is not a gift, it's a trap. Insurance companies push fast settlements for one reason and one reason only, because a fast settlement almost always means a cheap settlement. And once you sign that document, it's over. Today, I'm going to show you exactly why they do it and how to protect yourself. Hey folks, I'm Derrick, a personal injury lawyer here in Simpsonville, South Carolina. I've spent years going up against insurance companies on behalf of South Carolina families. And I can tell you firsthand, these companies have a system, a deliberate, calculated system designed to close your case as fast as possible for as little money as possible. I started this channel because you deserve to understand what that system is before you pick up the phone. And by the end of this video, you'll understand exactly why the insurance companies push fast settlements, what they're actually afraid of, and the specific tactics they use to get you to take less than you deserve. I'm also going to walk you through what the settlement process actually looks like and what changes the moment you have the right lawyer in your corner. Now let's get into it. Here's something most people don't know. 95% of all personal injury cases never see the inside of a courtroom. They settle. And that number doesn't even include the vast number of cases that never get filed in the first place. So if almost every case settles anyway, why does it matter when you settle? Because there is a massive difference between settling on your own terms and settling on theirs. And the insurance company knows exactly which one they're pushing you toward. Here's how they think about it. Every single day your case stays open, their risk goes up. The more treatment you get, the bigger your medical bills grow. The more documentation you build, the stronger your case gets. The moment you hire a serious lawyer, one they know will actually take them to trial, their math changes. So what do? They call you early, they're polite. They make a number sound extremely reasonable. They create urgency and they get you to sign something before you know what your case is actually worth. I see this happen to good South Carolina families all the time, and it doesn't have to happen to you. Let me show you exactly how this works. Now, mistake number one is taking the early settlement offer before you know what your case is actually worth. And this is a big one, and it's the one I see most often. Right after a wreck, before you finish treatment, before you even know the full extent of your injuries, that adjuster calls you with an offer. Maybe it's 1,500 bucks, maybe it's 5,000. They'll say something like, "We want to take care of you. We can get this resolved quickly and take care of your medical bills." It sounds reasonable, right? But here's what they're not telling you. That offer is based on what they know right now, which is almost nothing. They don't know if you're going to need surgery. They don't know if you're going to be getting treatment for the next 6 months or more. They don't know what your lost wages are going to look like, but you don't know those things either. And that's exactly why they're calling you right now. And here's what is actually required. You need to finish your treatment and know the full value of those three buckets, your medical expenses, your lost wages, and your pain and suffering, before you even think about settling your claim. And what I want you to do instead, tell them you're still treating. Tell them you'll be in touch when you're done. And do not sign anything, period. Mistake number two, assuming a settlement offer means they think that your case is weak. Here's something that surprises people. When the insurance company makes you an early offer, a lot of people think, well, maybe my case isn't that strong. Maybe I should take it. It's wrong. It's actually the opposite. They're making you an offer because it's proven to save them money. They're making you an offer because they've looked at the facts. They've seen the police report. They know their driver was at fault. And they want to close this out before you figure out what it's really worth. Think about it this way. Insurance companies are in the business of math. They don't throw money at weak cases, despite what you've heard. They spend money to save money. And here's the reality check. The gap between what they offer early and what the case is actually worth can be freaking enormous. I've seen situations where insurance company offers $10,000 on a case that's worth $500,000 or more. That gap exists because they're betting you don't know the difference. Now, what to do instead? Don't interpret an early offer as a ceiling or a sign that you have a bad case. Interpret it as a signal that your case has value. Then go find out exactly how much. Mistake number three, not understanding what changes when you hire the right lawyer. Now, here's something the insurance company definitely doesn't want you to know. The moment you hire an attorney, specifically one they know who will actually hold their feet to the fire, their calculation changes. See, insurance adjusters know which attorneys will fight and which ones won't. They know which firms will file a lawsuit, which ones will keep negotiating forever. And when they're dealing with someone they know will go to trial if necessary, they get serious and fast. Why? Because trials are expensive, trials are unpredictable, juries are unpredictable, and a bad verdict doesn't just cost them money on your case, it sets a precedent. Here's what I've seen firsthand. Cases that were stuck at a lowball offer for months suddenly get real movement the moment the insurance company realizes they're dealing with someone who will actually go to the mat for their client. What to do instead? If you're getting lowballed, talk to a lawyer, not just any lawyer, but one who actually tries cases. That distinction matters more than most people realize. Mistake number 4, thinking the process is over if they don't settle pre-lawsuit, okay? A lot of people think that if an insurance company won't settle early, they're headed straight to a courtroom. That's not how this works. And that fear is something that insurance companies actually use against you. Here's the reality. Even after a lawsuit is filed, 95% of cases still settle before trial. Actually, South Carolina courts require both sides to go through a mediation process where a neutral third party sits down with everyone and tries to get the case resolved. And more often than not, it works. Filing a lawsuit is not the end of the world. It's actually a tool to bring them to the table if they're not there. It gives your attorney subpoena power, the ability to take depositions, and access to evidence that the other side wouldn't hand over voluntarily. All of that makes your case stronger, which makes the insurance company more motivated to resolve the case. So what to do instead? Don't let the fear of a lawsuit push you into a bad settlement. Understand that filing suit is often just the next step in the negotiation, not a trip to the courtroom. Now, mistake number 5 is waiting too long to get legal advice. This is fancy coming from a lawyer at this point in time, right? A lot of folks think they should wait until they're done treating, wait until they know how bad it is, or wait until the insurance company makes a move. And by the time they talk to a lawyer, they've already given a recorded statement, they've signed a document they shouldn't have, or they've stopped treating when they were still hurting. Here in South Carolina, you have 3 years from the date of the crash to file a personal injury lawsuit. That sounds like a long time, but evidence disappears, witnesses forget, medical records can get harder to pull together. So the earlier you get advice, the better position you're in, even if you end up handling parts of the process yourself or the whole case yourself. So what to do instead? Talk to a lawyer early. Most personal injury lawyers, including our firm, don't charge anything to review your case. You've got nothing to lose by getting informed and potentially everything to gain. Here's what I need you to understand before I wrap this thing up. The insurance company has been doing this a lot longer than you have. They have adjusters who have handled hundreds of claims a year. They have attorneys on retainer and a system that is specifically designed to move your case through as quickly and cheaply as possible. That friendly phone call, that reasonably sounding offer, that sense of urgency they create, none of that is accidental. It's all part of the playbook. But the good news is that once you understand the playbook, you can stop playing by their rules. You don't have to take the first offer. You don't have to give a recorded statement. You don't have to rush. This is your case, your recovery, your family. Take the time to do it right. Here's what I want you to do. Do not accept any settlement offer on the personal injury side of your case until you have completed all of your medical treatment and know the full value of your case. Do not give a recorded statement to the at-fault driver's insurance company. Remember, you're not required to do that, and it will only be used against you. Document everything. Medical bills, lost wages, pain and suffering, missed activities, fill up every bucket. Don't let fear of a lawsuit push you into a bad deal. Filing suit is a tool, not a threat. And talk to a lawyer early before you make any major decisions about your case. Now write those down, because when that adjuster calls and they're being real nice and real reasonable, you're going to need to remember them. Here's the bottom line. Insurance companies push fast settlements because fast settlements are cheap settlements. They are counting on you not knowing what your case is worth. They are counting on you being stressed, being in pain, and being ready for this to be over. Don't give them that. Get your treatment, build your documentation, understand the process, and if the gap between what they're offering and what your case is actually worth is too big to bridge, talk to someone who will go to the mat for you. Now, if this video helped you, hit subscribe. That tells me you want real information from a real lawyer, not the runaround. And if you know someone who's dealing with an insurance company right now, send this to them. It might be the most important thing they watch this week.